humbly request all our esteemed guests to please be seated. We'll start soon. Let people sit. Let people sit. We would like to welcome, on behalf of Adhivakta Parishad Supreme Court Unit, to today's function wherein we all have come together for the study circle and felicitation ceremony of the newly designated senior advocates by Supreme Court of India. We would also like to extend our warm welcome to our esteemed guest, all dignitaries, respected senior advocates, seniors, juniors, and my dear friends.
Now we would like to invite our chief guest, Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India, and guest of honor Mr. Mahesh Jethmalani, Senior Advocate Supreme Court of India, to grace the dais with their august presence. We would also like to call upon Mr. Vinay Navare, Senior Advocate President of Adhivakta Parishad Supreme Court Unit, Mr. Rasneet Singhania, Vice President Study Circle IAM Supreme Court Unit, Mr. Bhaskar Gautam, Secretary of Adhivakta Parishad Supreme Court Unit, Ms. Archana Surve, Member, Adhivakta Parishad Supreme Court Unit.
We would request our esteemed guests and dignitaries to inaugurate today's program with lighting of the auspicious lamp. I'll request Richa ji to also come here and facilitate the same.
दीप ज्योति परम ज्योति दीप ज्योति नमो नमः दीपो हरतु मे पापं दीप ज्योति नमोस्तुते शुभं करोतु कल्याणं आरोग्यं सुख संपदा द्वेष बुद्धि विनाशाय दीप ज्योति नमोस्तुते दीप ज्योति परम ब्रह्म दीपो ज्योति जनार्दन दीपो हरतु मे पापं संध्या दीप नमोस्तुते
request everyone to please stand up and request Richa ji for Vande Mataram.
वन्दे मातरं वन्दे मातरं सुजलां सुफलां मलयज शीतलां सस्यश्यामलां मातरं वन्दे मातरम् शुभ्रज्योत्स्ना पुलकितयामिनी फुल्लकुसुमिता द्रुमदलशोभिनी सुहासिनी सुमधुरभाषिणी सुखदां वरदां मातरं वन्दे मातरम् कोटि कोटि कंठ कल कल निनाद करने कोटि कोटि भुजै धृत घर करवाले अबला के नुमायत बने बहुबल धारिणी नमामि तारिणी रिपुदल वारिणी मातरं वन्दे मातरम् तुमि विद्या तुमि धर्म तुमि हृदि तुमि मर्म त्वं हि प्राणः शरीरे बहुते तुमि मा शक्ति हृदये तुमि मा भक्ति तुम्हारे प्रतिमा गढ़ी मंदिरे मंदिरे वन्दे मातरम् त्वं हि दुर्गा दश प्रहरण धारिणी कमला कमलदल विहारिणी वाणी विद्यादायिनी नमामि त्वां नमामि कमला अमला अतुला सुजला सुफला मातरं वन्दे मातरम् श्यामलां सरलां सुष्मितां भूषितां धरणीं भरणीं मातरं वन्दे मातरम् वन्दे मातरम्
भारत माता की
जय।
I'll request our President, Supreme Court Unit, Vinay Navre sir, to present a memento to the chief guest. Now I'll request our Vice President of Adhivakta Parishad Supreme Court Unit Study Circle IAM, Rashmi Singhania ma'am, to present a memento in a book to our guest of honor.
Now we would request Bhaskar Gautam ji, Secretary of Adhivakta Parishad Supreme Court Unit, for a short introduction about the organization.
नमस्कार।
Namaskar, good evening everyone. Akhil Bharati Adhivakta Parishad is an all India organization of advocates. Adhivakta is a Sanskrit word for advocate. The idea that sprouted as a seed in 1992 to create an umbrella of lawyers organizations in India has today grown to become a giant banyan tree which has its roots and branches across India from Kashmir to Kanyakumari and Kamrup to Kutch. From Supreme Court to all High Court benches, from 46 units to 600 district courts and 12 tribunal units till taluka and sub-divisional level, we have our presence marked across the length and breadth of the country. Our motto is Nyaya Mama Dharma. Justice is my dharma. The organization is inspired by the ideas of service to nation and to the people of India, contributing to the ease of living for citizens, as well as revival of the national glory and rebuilding our nation and civilization. The organization makes timely interventions in justice delivery mechanism and makes far-reaching contributions to law-making process for the welfare of citizens and rejuvenation of vital institutions of the nation. Adhivakta Parishad is making sincere efforts to train and nurture budding young lawyers to become skilled advocates with commitment to social justice and national development for the establishment of a strong, effective and accountable justice delivery system, immune to external pressures and corruption. The inspiration behind the formation of Adhivakta Parishad was the urgent need to inculcate nationalistic spirit among the advocate community while helping them to enhance their professional skills. The underlying thought being that an enlightened and competent lawyer will be an asset to the society who is in quest of solutions and remedy to emergent issues in the changing times. Adhivakta Parishad has been organizing study circles wherein advocates across generations regularly meet to discuss various statutes, case laws and contemporary issues ranging from national to regional levels, having impact over the society. Nearly 600 study circles are functional throughout the country as on date. Adhivakta Parishad has also been organizing its one-of-a-kind initiative named as Nyaya Kendra on the concept of providing free legal aid by camping in the remote rural areas of slums, going to the poor, downtrodden and deprived sections of society by listening to them and aiding and advising them for a remedy to the problems being faced by them. We also conduct regular workshops, seminars, symposiums for enhancing the skills of advocates with support of guidance of all the senior members of the bar and academicians from various law faculties. Additionally, we've also been trying to create an interface platform where social organizations, advocates, academicians interact to bring necessary changes to the legal system and to make it more people-friendly. Adhivakta Parishad also publishes its quarterly magazine by name Nyaya Pravaha, containing articles on various socio-legal issues which are contributed by judges, advocates, academicians, law students and researchers. As on date, the magazine has a readership and subscription base of around 12,000 across the country. Friends, we have been striving to ensure availability, accessibility, affordability and acceptability of justice to even the last person at the far end of the society. In furtherance of the said mission, we have initiated stakeholder discussions and deliberations in the society and passed resolutions and taken up these issues at various levels with the connected to address the lacunas and loopholes of justice delivery system. Adhivakta Parishad requests all advocates and esteemed members of legal fraternity present in the audience today to come and connect, contribute to the cause of justice. Thank you.
Thank you, Bhaskarji, for amply putting in words what the organization is all about, how we function, what is our motto, and what values we stand for.
Now I would like to request Vinay Navreji to throw some light on the criminal topic of new criminal laws the way ahead. Vinay Navre sir started practicing on the appellate side on Bombay High Court in 1988. He completed his LLM in Constitutional and Property Law in Mumbai in 1990. and his second LLM from Netherlands, International Law in Groningen University. He moved to Delhi in 2004 and he has been practicing here and is also a senior advocate. I request sir to please come and take the dais.
Honorable Justice Uday Lalit, Honorable Mr. Mahesh Jethmalani, my friends on the dais and my friends in this auditorium. The topic that we have chosen today and the speakers that we have been fortunate to have today, I think we call it in Marathi or Hindi, Dugdha Sharkara Yog. Best possible persons in the field of criminal law that are available today in the country, and we are lucky to have them here for this topic. We all know, and Mr. Justice Lalit is not here because he has been a judge and a former Chief Justice of India. But I know, I have personally seen, and many of us have seen, that he was actually a most prominent criminal lawyer, not only criminal lawyer, this is not to undermine, but most of the prominent cases, those were spoken of, those were the topics of the newspapers or media, and you will see that Mr. Lalit has appeared in those matters. So I think all of us are extremely lucky that we have the best possible persons available to guide us on the subject. Initially, it was informed by Varunji that I will say something on the topic. To be very frank with you, I have no courage to speak on the topic for which we have the most competent persons who are going to deliver their speeches. As Adhivakta Parishad, most of you know that I have been associated with Adhivakta Parishad for last many years, but actual active involvement has started after I became the president of the Supreme Court unit. And this is the first study circle that we are having in such good numbers. Advocates are attending, and the topic and the dignitaries that we have for the topic, I think this is the very good beginning for a new team of Executive Committee of the Adhivakta Parishad Supreme Court unit. I am aware that I am not the speaker on the topic, and therefore I am not going to be in the way of our dignitaries offering their thoughts on the subject. The only thing I can say is that the topic that we have, it will be the lectures that will be delivered. It will be just the beginning of the thought process for all of us. And I hope that we carry on that thought process in our informal discussions, in our actual practice. And that's the way we can use the study circle today. Thank you very much.
Thank you so much, sir. We would request our guest of honor, Shri Mahesh Jethmalani, Senior Advocate, Supreme Court of India, to guide us over the topic. Shri Mahesh Jethmalani. Shri Mahesh Jethmalani is a senior advocate at Bombay High Court. He completed his Bachelor of Arts from St. Xavier's College, Mumbai, and his Master of Arts from Oxford University. Mr. Jethmalani has appeared in several important cases before Bombay High Court and Supreme Court of India. He has represented the Birla family in the Premwada Birla case. He also appeared for Anil Ambani in the Reliance case. He had conducted and had assisted in the trial of ex-Chief Minister of Maharashtra, A.R. Antle, and appeals. Other cases include the trial of Harshad Mehta in the Maruti Udyog case, for Rajni Patil in the Professor Vishram Patil murder case, in which the brother of ex-President of India, Pratibha Patil, was a suspect. Sir, please.
No, my tenure has just ended, but I'm hoping for a renewal. Honorable Chief Guest, retired Chief Justice Lalit, Mr. Navre, President of the Adhivakta Parishad, other officers of the office bearers of the Adhivakta Parishad on the dais, my colleagues at the bar, ladies and gentlemen. This must be about the 10th speech I'm making on these 3 new laws. So I'm trying to think of a different angle as to how to make it more interesting. But unfortunately, there's so much material which has already come out in the press by critics of this that I thought I'll say something about why this law was passed and what are the criticisms which are unjustified and what are the criticisms which need to be taken note of. Very briefly, I'll do it. First of all, let me just say that a little background, that this idea of these 3 new laws commenced during COVID period. And I was asked by the Home Ministry, under whose aegis these laws were to be prepared, to become a member of the Reform Committee. And I took up the task, and fortunately during COVID we had a lot of time. So we went through all these laws. We had a very good team. Professor Bajpai was the chairman of the Reform Committee. There were some very young and enterprising students. And the output was huge. I mean, we examined almost every provision. We examined stakeholders. We suggested reforms. We then got back suggestions, counter-suggestions. We tried to improve upon what we had put out. Finally, the matter went to the Home Ministry because the agencies had to be consulted. And substantially what I may say was a fairly liberal, human right-oriented document or suggestions was watered down, and security of the state, which I now agree with a lot of provisions pertaining to security of the state took precedence, and human rights took a little backseat. All in all, the new laws are not only needed, but make for a break from the colonial past. This is particularly true of the new Indian Penal Code, the Bharatiya Nyaya Sanhita, the new Criminal Procedure Code, the Bharatiya Nyaya Suraksha Sanhita is Nagrik Suraksha Sanhita, which replaces the Criminal Procedure Code, is very far-reaching in its thrust. Mainly, it aims at expeditious trials and investigations, and also the use of technology in criminal procedure, particularly during investigations and trials. And thirdly, the Indian Evidence Act, fortunately, not much has been tampered with because our rules of evidence have stood the test of time. But the thrust is some colonial expressions used in the Indian Evidence Act have been done away with. And again, the technological innovations such as electronic evidence, etc., have now been introduced in the Indian Evidence Act. So that's the basic broad features of the 3 new laws. Now, why was this necessary? First, it was necessary, the obvious reason, that these were antique laws. They belonged to a colonial era, and we had to make a break. I mean, independent India had to make a break from its colonial past. We had to have our own independent statutes. These were created, and as you'll see, some of the provisions were created for the benefit of our colonial masters. Some had become outdated completely. And with the passage of time, technology innovations had to be taken into account in these 3 statutes. Now first, let me give a brief overview about the Sanhita, the Bharatiya Nyaya Sanhita, which replaced the Indian Penal Code. There are many provisions which have been introduced. There have been a lot of people say that this is old wine in new bottles, but actually there are many new thrusts and aspects in the new Bharatiya Sanhita, Nyaya Sanhita. Now, it is to be welcomed only because, as I said, it constitutes in independent India a complete review of a partly obsolete colonial law, crafted to serve the interests of a colonial power, and supplants it with a new substantive law that retains what has been proven effective post-independence, but amends some existing provisions. Additionally, it adds fresh ones that consider 76 years of experience in the operation of the repeal law. At one stroke, the Sanhita retains the bulk of the Indian Penal Code, but introduces significant new provisions. So the approach to the repealed colonial law is not ideological and radical, but it is adaptive and reformist. Now, one of the main concerns reflected in the amendments of the IPC provisions and the introduction of new ones in the Sanhita is the security of the Indian state. Now, this is replaced, this is best reflected in the change in the sedition law. Under the old sedition law, what was sought to be punished was any writings or actions which caused disaffection against the government of the day. Now, those words reflected that the object of the sedition law was really to protect the government, the colonial government of the day, from its subjects. Now, this led to a lot of criticism. 124A, as it was sedition, led to a lot of criticism, saying that it's a colonial law, it helps the government of the day to curb dissent by citizens, and it must be done away with. So the change was introduced, and the new law is now, the new section, and the change brought about it, right, is section 152 in the Nyaya Sanhita. Effectively, what has happened is the word sedition, which has a controversial connotation, has been done away. The new section describes the offense as an act endangering sovereignty, unity, and integrity of India. The section imposes a life sentence of imprisonment or imprisonment up to 7 years and a fine for anyone who by written or spoken words excites or attempts to excite secession or armed rebellion. So there are a whole category of overt acts which are sought to be punished. Excites or attempts to excite secession, armed rebellion, subversive activities, or encourages feelings of separatist activities or endangers the sovereignty and unity of India. So the shift now is from causing disaffection against the government of the day to causing disruptive activities of the different words which I've just recited. Secession, armed rebellion, subversive activities, etc. So no longer is the sedition law a law designed for a colonial master against its subjects, but it is now a law which, particularly in the light of external and internal threats, serves the interests of the security and integrity of India. And that is, the sedition is done away, disaffection is done away, but the object is to protect India's unity. Now, that is one of the main changes. Second are two, it does away with some anomalies. I'm surprised. There has been acute legislative neglect in this country. This should have been done a long time ago. Take, for instance, a very, very anomalous example. Abetting murder in India or abroad. This was dealt with by Section 108A. I'm just giving you a few examples. The sweep of these three laws are too wide to discuss in a 15-minute address. 108A said this, the old illustration, so this is abetment by somebody abroad of murder, for instance, in India. The old illustration said, A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abetting murder. The old 108A abetment from outside India treated Goa as not a part of India. Now, this was 1860, the penal code. But from 1860 till these new laws came in, the illustration to 108A reflected that Goa was not a part of India, part of the Portuguese empire, colonial empire, and the 61 liberation of Goa from Portugal was not taken into account all these years and continued to remain in the statute book. That's the break from the colonial, that's the kind of break from the colonial past. One is sedition, sedition, which was meant for the colonial masters to repress its subjects. B, to recognize realities that are part of India, that are part of what was not India under Portuguese occupation, and which should have been remedied much earlier, is now a part of India. So, the new section now reads, is section 48 now. A in India instigates B, sorry, it's 47 now. A in India instigates B, a foreigner, in country X now. So Goa has gone. To commit a murder in that country, A is guilty of abetting murder. Then, for 62 years, therefore, the Indian Penal Code contained this. They had not changed this because 1961 was when Goa got independence. Now, another colonial legacy consigned to the dustbins of history is Section 48. 47 is abetting murder in India or abroad. Now, this says abetment outside India for an offense in India. Now, the illustration to Section 48 made it clear why the acts prescribed as an offense by Section 48 did not find favor with the British. If a section corresponding to Section 48 in the Sanhita existed in the IPC, a British native instigating someone to commit a murder in India would be liable for punishment in India for abetting murder. This effect was unacceptable to the colonial government. Now, Section 48 of the Sanhita makes a person outside India liable to be tried and punished in India for abetting offenses in India. Most significantly, the illustration to 48 would permit the Indian government to try and punish masterminds behind terrorist offenses in India. The aim of 48 is to facilitate the trial and punishment of several terrorist groups. Hafiz Sajid Mir of the Lashkar-e-Taiba and Panoon of the separatist Khalistan movement are all now liable to be extradited and tried in India. In pursuance of this trend of the security of the state, crime and terror have been strongly punished. Now, organized crime had become a rampant evil in this country. Maharashtra, for instance, and some other states had enacted MACOCA, the Maharashtra Prevention of Crime Control Act. Now, MACOCA provisions have been brought in all India. Under 111, organized crime is an offense under the new Sanhita, unlike in the old penal code, and the provisions of the MACOCA have roughly been reproduced in the new Bharatiya Nyaya Sanhita. So also, under 113, the Sanhita defines and punishes terrorist acts. Now, the Unlawful Activities Act exists, but the Sanhita also has a provision for terrorist act. It defines terrorist acts in almost the same terms as the UAPA does. So one of the criticisms which is often voiced is, what do you do? Why are there two statutes and how do you distinguish the two? Where does one apply and the other cease to apply? Answer is, if the terrorist crime or the unlawful activity is localized, then it will be the superintendent of police in the given state who will address the crime. If it is to go to the NI, that superintendent of state will transfer it to the NI. Now the criticism leveled is, on what basis will a state superintendent, on what basis will he transfer? What are the grounds? There is no material. There is no rational criteria given to him for transferring it to the NI. Answer is obvious. If the crime is local, restricted within one state, then the officer in charge of the police station before whom the crime is committed, or the anti-terrorist squad in a given state, will investigate and prosecute. If it has cross-India dimensions, interstate dimensions, then it will have to be transferred by the officer in charge to the NIA. So that, although that is not explicitly spelled out, the grounds are implied, and the public criticism of these provisions, particularly by some opposition parties, is unfounded. Now, in keeping with Another broad feature, in keeping with the Prime Minister's announcement about a couple of years ago from the ramparts of the Red Fort, that Nari Shakti is going to be not only taken heed of, but implemented in every sphere of life. We had the 106th Amendment by which women's reservations in Parliament and legislative assemblies was introduced a year ago. In 2023, 2023 it was introduced. In continuation of that trend, we now have a special chapter, chapter 5, devoted only to offences against women and children. Now, this was not done. This recognition that there is a genre of crimes which affects mainly women is now incorporated by a specific chapter of 5 called Crimes Against Women and Children. Before, what happened is rape, for instance, a very serious offense, which women, as you know, today it's become legion, was being tried under chapters saying offenses dealing with bodily harm. Now all these offenses, which are scattered under different chapters, marital offenses were under a different chapter of the IPC, they are all now encompassed and brought about in a single chapter, chapter 5, dealing with offenses against women and children. Now, causing death by rash and negligent act, this is what experience has taught us. Young brats who drive fast cars and commit accidents now have an enhanced punishment for rash and negligent driving if they cause death. It's now 5 years. Equally, negligence by doctors is of a lesser degree of negligence. It's of a lesser, it is not culpable negligence as it is by the rash car driving, the young children who now, or young adults who now drive cars rashly at fast cars with supersonic speeds and run over innocent pedestrians. To take care of that, doctors are protected. They are not put on the same footing as the young car drivers, and the punishment for them remains under 2 years, a maximum of 2 years. Then the Sanhita also introduces a new punishment altogether, community service. It prescribes this for petty offences, including conspicuously the offence of defamation, which is liberally initiated in court proceedings now. Offence is now punishable under section 356(2) of the Sanhita. Now, another reason why the laws have become obsolete. The IPC imposed fines as punishment, be it as the entire penalty or as an alternative addition to imprisonment. These had not been increased in some cases since their inception in 1860. So, for example, the fine for voluntarily causing pain extended to a maximum of 1,000 rupees. Sanhita has enhanced these fines to a maximum of 10,000 rupees, and some say even that is not enough. Section 338 of the IPC also punished human endangerment resulting in grievous injury to others in 1,000 rupees. Sanhita has increased the fine to 10,000 rupees. So the quantum of fines was completely outdated, and the Sanhita had to rectify this. This should have been rectified a long time ago because the price of money, the value of money has appreciated tenfold or hundredfold. So now the Sanhita, there were fines unchanged in 81 other offences which have now been appropriately enhanced by the Sanhita. This was a necessary task. Again, a colonial relic not looked up. As I said, all these years there was a case of gross legislative neglect. Finally, as far as the Sanhita is concerned, the use of pejorative, undermining words, pejorative terms peculiar to a colonial age have all been done away. So words for people of mental disability are like, the IPC use words like lunatic, insane, idiot. One section uses the word idiot. Now these have all been done away. In the Sanhita, in section 89, general exceptions contains heading acts done in good faith for the benefit of child or by the consent of guardian. All these words have now gone. And the language of the Sanhita is now compassionate and not pejorative. Now, I'll do a quick review of the Bharatiya Nyaya Suraksha Sanhita, which is actually a sterling piece of legislation. It's very good. It's introduced provisions by which technology is used at almost every stage. It also tries to keep timelines for the completion of discharge applications. Trials, of course, you can't fix a timeline. That's a great trouble because you don't know how many witnesses there are going to be in a case. Some cases, still have about, I'm doing a case tomorrow which has about 1,000 witnesses. And it's been given to me by the Adhivakta Parishad at the last minute today. And so these are some issues which the CRP, the new Bharatiya Nagrik Suraksha Sanhita, takes care of. Now, just to give you a quick idea, first of all, we have a Directorate of Prosecution, a new Directorate of Prosecution, much needed, a much needed institution has now been introduced. This Directorate of Prosecution will now monitor investigations and trials to make sure that their integrity, in a nutshell, their integrity and expedition are maintained. There should be no delay and there should be no unfairness to accused persons in the matter of investigation. Then, Section 175 of the BNSS, which is in identical terms to 156, makes it clear that you can file a zero FIR wherever it's filed. He can't investigate the offense, but a zero FIR should be filed. You can't now turn away a first informant and say, go to another police station, I have no jurisdiction. Zero FIR has to be filed, and that zero FIR then has to be transferred to a police station having jurisdiction. Then 156.3, all the changes made had been incorporated. It was incorporated by judicial pronouncements. They have now been made statute law. You have to file an affidavit saying before you move the magistrate under 156.3, you went to the officer in charge of the police station, you went to the superintendent of police, both refused, and therefore you have now come to 156.3 before a magistrate. Then every information has to be notified by every information given has to be notified by the state government post the lodging of the FIR. Section 176(1) of the BNSS provides that in relation to the offence of rape, the statement of the victim shall be recorded at a residence or a place of a choice as far as practical by a woman police officer. So there are all provisions for enhancing the safety, security and comfort of women in rape cases. Then technology, the use of technology to ensure integrity in investigation. To ensure the integrity of the search procedure by the police during investigation, firstly, the grounds of belief for conducting a search must now be recorded in a case diary as per the provisions of 185(1). This requirement is designed to prevent any recording of grounds ex post facto to the search. Section 105 is a very important new provision. It not only reinforces 185(2), but it ensures the sanctity of the entire search and seizure process by mandating that the process of conducting the search of a place or taking possession of any property, including preparation of the list of all the things seized during search and seizure, shall be recorded through any audio, video, electronic means, preferably mobile phones. So the entire search and seize process, no longer can there be any planting of evidence. In narcotics cases, this was a disease. This used to happen. Police officers have been prosecuted. Most recently in the Aryan Khan case. Now, the complete integrity of this search and seizure procedure has been mandated by audio-visual recording under 185(2) of the new Sanhita, of the Nagrik Sanhita. Now, this constitutes a most salutary step in ensuring unimpeachable search and seizure process. Hitherto, police investigations only consisted of concocted search and seizures proved ostensibly by doctored panchnamas, i.e. professional punches were used. Now you can't do that. The entire procedure has to be audio recorded. Now, let me get to two provisions quickly before I end. There's much more in this, and I haven't even come to the Evidence Act, but there's a very, very illustrious speaker and practitioner of criminal law, whom I've had the pleasure to appear before and with in the Bombay High Court, and before in the Supreme Court, of course. But two very, very important provisions, which seem to have been omitted and need rectification. One is Section 187.2, which replaces 167.2. Right? Now, as per a case called Anupam Kulkarni, defense practitioners particularly should note this. As per Anupam Kulkarni's case, your period of police custody had to be during the first 15 days of your remand. It couldn't take place afterwards. A change took place in Balaji Senthil's case. I think it was a judgment by Justice, bench headed by Justice Sundaresan. And he said that there is no ostensible reason why you can't be, for instance, if new evidence comes, why an accused person can't be arrested partly in the first 15 days and partly later on. Now, the Sahita has used language that says in parts, that the police custody period can be in parts. Senthil Balaji said that it can be during the entire period of 90 days for which remand can be granted. But the new code, the Nagrik Suraksha Sanhita, says that it can be only for the first 40 days in the case where the offense is punishable with 60 days and 60 days where it is punishable with 90 days. So it curbs the period during which you can have a second arrest, for instance. But there's a word which says parts. The section uses the word that you can be sent to police custody by a magistrate in parts. Now, if it was just two parts, one could understand. But both Senthil Balaji's case as well as the present Sanhita, both of them, unfortunately, now use the word parts, which means that for the 15 days period, you can be remanded to judicial custody, to police custody, 15 times for 1 day each. Now that's a travesty and that has to go. Somebody has to amend the section and say either in 2 parts or maximum 3 parts. I think 2 parts is enough for somebody to go to jail, to go to police custody twice. 2 parts should be enough. So as a happy compromise, otherwise the wording of the section leaves it open for prosecutors to say I can arrest him 3, 4, 5 times, so long as my total period is only 15 days. That abuse can be rectified by changing parts to 2 parts. One last example, but I have to revert back to the Nyaya Sanhita, the Indian Penal Code replacement. In that 377, while it captures Navtej Sidhu's case, which is to do with homosexuality and LGBT sex, 377 had a clause saying which prohibited and punished sexual relations or carnal relations, as the word was used, with animals. Now, the abolition of 377 together leaves open that needs to be plugged. 377, while the other unnatural acts, because homosexuality and same sex is no longer an offense, it needs to be rectified to the extent that unnatural act, you don't have to use the word unnatural acts, carnal acts with animals should continue to be prohibited. That's what's called a casus omissus by the legislator. It should be introduced to prevent a very serious public mischief. And it's not that these don't happen. These happen quite frequently, particularly in the rural areas. Ladies and gentlemen, I run out of time, or exceeded my time. I apologize to all my co-panelists over here. But let me just say, in conclusion, that these 3 laws are a much-needed anti-colonial innovation. They were much needed. There's a break from a colonial past. This is India. This is in keeping with India's independent spirit. We are now an independent nation, and we don't have to have laws inherited by and for the benefit of a colonial master. So I thank you all very much for this patient hearing. Jai Hind.
Thank you, sir. Honorable Mr. Justice Umesh Lalit was born on 9th November 1957. He was enrolled as an advocate in June 1983, practiced in High Court of Bombay, and in December 1985 shifted his practice to Delhi. He was designated senior advocate in April 2004. He appeared in amicus curiae in many matters as a special prosecutor for CBI and also conducted a special public prosecutor for 2G cases. He was member of the Supreme Court Legal Services Committee for 2 terms and was appointed the judge of Honorable Supreme Court in 2014. He was also the chairperson of National Legal Service Authority from May 2021 to 27th of August 2022. Thereafter, he became the Chief Justice of India, and presently he is Distinguished Visiting Professor, Asank Desai Center of Public Policy Studies, Indian Institute of Technology, Bombay, and many other universities. Sir, I will humbly request you to please take the dais and enlighten all of us with your views. Thank you.
Thank you. Mr. Mahesh Jethmalani, Senior Advocate, Supreme Court and Member of Parliament. Mr. Vinay Navre, the President of Adhivakta Parishad, all the other office bearers who are either on or off the stage, or office bearers of the Adhivakta Parishad. I see some of the senior advocates who have recently been given the distinction, so therefore all those persons who have recently been designated by the Supreme Court, congratulations. And I see most of the advocates, I can name them, but pardon me if in last 10 years or so, perhaps I have been out of touch. So therefore, it may be that I may not be able to name them or put them in that place. Very well, 2 things before I commence my address on the topic for discussion. One is, of course, congratulating the senior advocates, and the second is, I heard a very beautiful rendition of Vande Mataram today. And believe me, I'd never heard Vande Mataram sung so beautifully and in its full, complete sense, all 5 stanzas. I've always heard Vande Mataram either the first or the second, and being stopped at that level, so therefore it was a wonderful rendition, so therefore congratulations. Now coming to the topic, I won't repeat what Mr. Jethmalani has said. We normally follow a convention that a council who has said something, the second council or the succeeding council need not repeat that. So therefore let me put the matter in a different perspective. 1985-87 saw Terrorist and Anti-Disruptive Act, Prohibition Act, that is TADA what we call. TADA came out with a concept which was hitherto unknown, and that is to say that a police officer could record confession of an accused. That confession of an accused could be taken as an admissible piece of evidence, not only in the trial of the confessing accused, but even as against the co-accused. I still recollect in Kartar Singh, a blistering attack was leveled by the then doyen at the bar, Ram Jethmalani, saying that, this is something unheard of, that a police officer can record the confessions and such kind of document can be relied upon in the trial. Similarly, TADA was repealed sometime in 94, so it had a very limited life, that is 87 to 94. We did not have any legislation which incorporated or borrowed the same idea. Till what we saw was 1999 MOCA legislation or MCOC legislation. MCOC legislation, which was enacted by a state legislature, Maharashtra, followed the same principle, giving the power to the police officer to record a confession with the same kind of consequential results. That is to say, it can be relied upon, and it can be relied upon even against a co-accused. The model appeared to be very, very attractive for some of the other states. Karnataka, Gujarat, Madhya Pradesh, Rajasthan, everybody borrowed that and implemented it as their own legislation, trying to control what is called organized crime. So much so that even Union legislature adopted it for NCT of Delhi. MCOC had one more idea, which was a very, very drastic idea, which was introduced for the first time, and that is, the police officer could intercept telephonic or mobile conversation. Interception of such conversation could then be placed before the court as a reliable piece of evidence on the basis of which perhaps even conviction could be recorded. In order to give some sense of security or sense of confidence, the permission had to be obtained beforehand from the authorized officer by the police officer saying that I wish to now intercept the conversation between two individuals, including one accused. So therefore, the intervention of an authorized officer and the review committee, which would then go into the question whether such authorization was rightly granted or not, and whether such authorization should be continued or not. Two kind of safeguards. But nonetheless, telephonic conversation, which is invasion of privacy of an individual, could be taken as a valid piece of evidence in a trial. And mind you, 1999 was borrowed by so many states, so therefore for them it happened to be an ideal model to follow. Very well, so we have these two legislations. TADA having been repealed in 1994, 2002 we saw POTA coming into force. Before that, of course, there was ordinance. But a regular legislation which was passed by the competent legislature saw the light of the day in 2002, but was a very short-lived. It was repealed in 2004. But again, POTA had the same logic, which is to say police officer can record a confession of an accused. So we had terrorist law defining something, what is terrorist act. We had set of legislations defining what is continuing unlawful activity, both borrowing this principle, that is to say police officer can record confession. MCOC Act going a stage further, that is to say interception of telephonic conversation as well. In light of all these prior developments, you know, the fact that 111 and 113 of now Bharatiya Nyaya Samhita, which is equivalent of IPC, now incorporate terrorist act and continuing unlawful activity as definitions into the central law, minus, and mark this, without having any kind of appropriate provisions either incorporated in Bharatiya Nagari Suraksha Samhita, that is to say law of procedure, that a police officer can record confession, is to my mind a fabulous step which has been taken by the Parliament. This is the way ahead. This is what a democratic society is meant to behave and conduct itself. And the blistering attack which was leveled by Ram Jethmalani and Kartar Singh now finds a way in saying that we must bury that ghost for all times to come. and we will not permit police officers to record confessions. If at all the confession has to be recorded, it must be under 164 of the CRPC, or what is equivalent to 164 in Bharatiya Nagari Suraksha Samhita. So this, to my mind, is the greatest contribution made by Bharatiya Nyaya Samhita in present day circumstances. Now, you're all lawyers. There are 7 states in which NCOC or act equivalent to that still prevails. This is you don't need to be told that on a concurrent list topic, if there are 2 legislations, one by the union and one by the state, which must prevail. So therefore, this will actually lead to a lot of debate, because the very same offense can be an offense under MCOC or Karnataka Organized Crimes Act or Rajasthan Organized Crimes Act, the state legislation, and it can also be an offense under the new law, which is the Bharatiya Nyaya Samhita. Now, in a situation where the police officer records a confession under the power supposedly drawn under that state law, what shall be the scenario is perhaps, I think, for you lawyers to fight in a given case. But therefore, this is what one area to my mind, and that's the very beautiful way what the legislature or the parliament has actually thought of. That's one. Second, we all know that what is the rigor of Masalti law. If there is a mob which comes and attacks somebody, then Masalti had actually brought in a concept of what is called to be on the safer side. Let there be something against that man. Correct? So therefore, in the normal circumstances, 149, the earlier 149, whenever we would rely on that, unlawful assembly, if there was a large mob, then we would rely on certain safeguards to first of all identify those persons beyond any doubt, and in some cases also say that what is the role attributable to them. Perhaps I think in the new definition of what is called mob lynching, which is a new offense under the Bharatiya Nyaya Samhita, I think that Masalti perhaps has been given a decent burial. So therefore, one can say that yes, when it comes to mob lynching or offenses committed by sizable number of people on the ground purely of religion, etc., etc., so therefore perhaps I think different considerations must follow, which means that we are now incorporating a different logic or principle for vicarious liability. That's also something very, very interesting and commendable. Then the fourth area. You know, there was this very beautiful case where Supreme Court said that if a man is undergoing life sentence for an offense of murder, and if he commits murder, another murder, the law obliged under 303 that he must be given death sentence. The Supreme Court said that how can you take away our discretion in the matter? So therefore we still have the power to award him life sentence. There are 2 such sections, 303 and 307, where a person who was undergoing life sentence, I'm saying 303 or 307, I still go by my notions under the old law, which is IPC law. 303 and 307. So there would be death sentence. But by judicial interpretation, we read into it and said that very well the discretion to grant life sentence is not taken away. Now the legislature has incorporated one more sentence, which is to say that life sentence till the last breath of that man. So therefore this new jurisprudence which has developed after that Hariharan's matter is now something which has been given legislative sanction through the ideas which are parallel to 303 and 307. very, very, and this is something which Mr. Jethmalani said, so therefore I won't repeat that. What was equivalent to 304A, the earlier 304A, despite loss of life, people would get away by sentence which was just about 2 years. So therefore now it gets raised to 5 years in normal circumstances. If it is medical negligence, 2 years. But if in a hit and run case, if the driver flees from the scene, leaving the man without any medical aid, then it can even be 10 years. And that is to say that this for the first time actually brings in a concept where that even an accused who happens to be somebody who is driven by normal human considerations, the sentence should be at a lower level. If he stays back, if he wants to give medical aid to that person, injured person, and doesn't run away from the scene, then for him the sentence will not be 10 years, but it will be only 5 years, which will again is something very nice which the legislature has incorporated. One more feature. We used to say that a minor girl being procured so that she could be driven to what is called illicit intercourse would invite punishment under the old IPC. Now, gender neutrality has been brought in that particular facet of the matter to say that whether it is minor girl or boy, anybody who has been procured for that illicit intercourse, naturally the offender will be dealt with on the similar lines. But there are certain things. I'll just respond to what Mr. Jethmalani said on what is now 187 or what was earlier 167. In Anupam Kulkarni, again argued by Mr. Ram Jethmalani, the Supreme Court said that yes, the limitation is 15 days, but the first 15 days of your custody. So if you are arrested on say 1st of January, the power to grant police custody would expire on 15th of January. Thereafter, it had to be only judicial or magisterial custody. Now, there were so many accused persons who would masquerade an illness or something and get hospitalized immediately after arrest, and thereby scuttle the chances for the investigating machinery to effectively interrogate the man. You recollect in one of the judgments, Justice Thomas said that custodial interrogation is elicitation oriented, has a different kind of significance. If we accept that in theory, then should we not then give that opportunity to the police investigator to effectively investigate into the matter? And that's why perhaps a welcome change, I won't say it appears to be casus omissus, it appears to be a deliberate attempt on part of the legislature. And that is to say that very well now, 15 days police custody, yes, but if it happens to be a normal offense for which the maximum custody can be 60 days, under 187 or erstwhile 167, within which time the charge sheet has to be filed, or thereafter there will be default bail. Now in that case, it is in first 40 days, 15 days custody in parts can be granted. Effectively what it would mean is, if he is arrested on 1st of January, first 10 days of custody till 10th of January, and then thereafter from 1st of February onwards, right up to 7th of February as well. So 15 days aggregate, but in first 40 days, if it happens to be a matter where charge sheet has to be filed within 60 days. If it's a heinous offense where the charge sheet can be filed in 90 days, then that 40 days will get elongated to 60 days. But police custody will remain at the level of 15 days, but not in one single tranche, but it can be in parts. Now that, according to me, is a very, very welcome idea by the legislature. Of course, you may fight in court battles, but according to me, that's something which is fabulously it was the need of the hour. There are, of course, yes, these community kind of service, etc., which are punishments, but very, very minor offences. So very minor offences, if you have that kind of community punishment, the extent of that community punishment, by very nature, can't be more than 5 days, 7 days, or at best, 15 days. It can't be exceeding that. I wish they had done something, sort of, expanded the net. There's one more area where I find, and perhaps I think the opportunity could have been utilized. It is true that there are certain kind of provisions which were in the nature of what is the colonial kind of historical baggage that we carried. And that baggage was in the form of law of sedition. Sedition has been given a recent burial. That's absolutely need of the hour. If you look at the last, the tableau just outside the Central Court of Bombay High Court carries what were the sentences which were Lokmanya Bal Gangadhar Tilak sentences. And it reads something like this, that despite the jury having been found me guilty, I still maintain that I am innocent. But if the laws of nature or something which demands my being incarcerated, then it will further the cause of the nation, then I don't mind even being sentenced. If you see Tilak on Trial, one of the beautiful books, and which was essentially relied upon in Kedarnath Singh by the then Constitution bench, it is Tilak's address which finds every time, read between the lines of that judgment and you will find, why does the court say that criticizing the policies of the government is no offense? Criticizing the policies of the government is a right of an every individual, just as Lokmanya Tilak said, it is Swaraj is my birthright, I can always demand it. And this is exactly what now, as a result of that deletion of sedition law, perhaps it is something which we have achieved. These are, of course, the silver linings. These are, of course, the advantages of overhauling the laws. But one opportunity, perhaps I think the legislature should have noted or taken note of, was Monument Committee report. Do you know that conviction is recorded in not more than 19% matters in the entire country, which actually means that 80% of the under trials who are imprisoned are finally let off, which means that they are found innocent and yet they are inside the prisons for a fairly long time. One way to address, and this is of course the usual, those persons who practice on the criminal side will always find it, whatever is projected as a police statement is very seldom stuck to by the witness in court. On many occasions, the witness resides completely out of that. Though there is a provision under 164 and the parallel provision under the Bharatiya Nagrik Suraksha Samhita that the confessions or the statements of the witnesses can be recorded. But what Monument Committee had suggested was something different. When we parted company with the old notions of code and brought in the new code in 73, we actually gave away or terminated one layer in the entire criminal process of trial, and that was the committing magistrate's intervention in the matter. Now today, committal has become more of a matter of course. The moment the charge sheet is filed, he just looks at it, what exactly is the offense, who are saying what, commits it straight away. At that juncture, give the discretion to the magistrate to record the court statements on oath of the witnesses concerned. and you will have the statements on oath which may then become the foundation for the entire trial. What will result is, perhaps at the earliest point in time, there will be a statement on oath which will then become impossible for the witness to resile out of at the stage of trial, and thereby ensure that some of the innocent persons are not put behind the bars for such a fairly long time. So the spectacle of seeing that more than 80% persons finally get acquitted is something which you will then be able to arrest, you will be able to control that. And this is something which Mallimat committee had suggested. So only one missed opportunity according to me. That's Mallimat committee. Otherwise, it has been a brilliant attempt. Thank you so much.
Thank you, sir, for enlightening all of us for your insightful speech. Now I'll request the Chief Guest and Guest of Honor to felicitate our newly designated Senior Advocates of Supreme Court of India. I'll welcome Mr. Abhimanyu Bhandari. I'm going in the alphabetical order. Abhimanyu Bhandari hails from Delhi. He completed his graduation from University of Buckingham and MPhil from University of Oxford.
Designation. So please be welcome.
Miss Aparna Bhatt has been an advocate on record in the Supreme Court. Ma'am has a strong academic background and decades-long experience in litigation and is well known for her expertise in constitutional law. Ma'am is widely respected and acclaimed for her contribution to public interest litigation and women's rights advocacy.
Sir comes from Qatar. He was an advocate on record. He has over decades of long litigation experience. Sir, we welcome you.
Mr. V. Balaji. Mr. V. Balaji has been an advocate on record at the Supreme Court. With over decades-long experience in litigation, Sir is well known for his expertise in IPR and commercial laws. Sir is widely respected and acclaimed for his dedication and contribution to the legal profession as a legal luminary.
Ms. Masuri Swaraj, she's a prominent lawyer specializing in constitutional, commercial and criminal law. Ms. Swaraj is graduate from Warwick University and Oxford University, a barrister in law from Inner Temple. In addition to her illustrious legal career, she has also begun her political inning as a member of parliament.
Mr. Davinder Pal Singh. Mr. Davinder Pal Singh is a seasoned advocate hailing from Punjab. Sir is known for his expertise in criminal law with extensive courtroom experience and a strong commitment to the cause of justice.
Mr. Gaurav Sharma, sir is an advocate on record. He comes from Pathankot, Punjab. He has more than 21 years of experience at bar and has made significant contributions in the field of civil and regulatory litigation, majorly MNCs, MCI, DCI, NBI Union of India and IIT Delhi.
Ms. Indra Shawne, with advocate on record, Ms. Indra Shawne is widely known for her work in constitutional law and social justice. Respected known in the legal community, she has been a part of several landmark cases and continues to be a strong advocate for equity and fairness in the legal system.
an advocate. Ma'am was an advocate on record since June 2007. She specializes in tax litigation as well as criminal and arbitration. Ma'am was a senior partner at Vash Associates, New Delhi. Ma'am, we welcome you.
Ms. Kalwanjeet Kochar. Advocate Ms. Kalwanjeet Kochar is renowned for expertise in family law and her empathetic approach to her clients' issues. Based in Delhi, she has successfully handled numerous sensitive cases, earning her a reputation as a compassionate and effective advocate. We welcome you, ma'am.
Mr. Mahesh Chandradinga, sir. Sir has known name in service and administrative law. His extensive experience in handling complex legal issues and his dedication to his client has made him a respected figure in legal fraternity.
Mr. Manish Goswami. Mr. Manish Goswami, with roots in Assam, has been a prominent advocate specializing in criminal law. He has been associated with Mr. P.P. Rao, senior advocate. His ability to navigate intricate legal challenges has earned him this prestigious designation.
Ms. Manisha T. Karya, ma'am has been an advocate on record handling corporate commercial disputes. She completed her BSL LLB from ILS Law College, Pune. She is a co-author on the book Electronic Evidence, published by LexisNexis and Butterworth. She is a trained mediator from International Center of Administrative Dispute.
Mohammad Rafat Shamshad. Advocate on record, Mr. Rafat Shamshad hails from Bihar. He has been Additional Advocate General for the state of UP. He is a well-known name in civil and human rights law, has been a persistent advocate for marginalized communities.
Dr. Ms. Monica Gosai, earlier advocate on record. Her independent practice started in 1993 after passing from Campus Law Center, Delhi University. She represented the state of Punjab, Haryana, and Union of India and other government authorities. Her scholarly approach to legal challenges have distinguished her as a leading advocate.
Mr. Nachiketa Sudhakar Joshi, advocate on record. Mr. Nachiketa Sudhakar Joshi hails from Bihar of Gujarat. He is currently serving as representative for the state of Madhya Pradesh. He completed his graduation from ILS Pune in the year 2003. Previously, Sir has also served as the General Secretary of the Adhivakta Parishad Supreme Court Unit. We continue, sir.
Mr. Lalit Kohli, a prominent lawyer with a background of media and international criminal law. Mr. Kohli also has been actively involved in public policy and governance. His diverse experience and legal expertise have made him a well-respected figure in the legal community.
Mr. Rangam Jr. Mr. Jr. hails from state of Manipur. He has completed his graduation from ILS Law College, Pune. He has over 20 years of professional experience and has been practicing corporate commercial dispute matters with a specialization in oil and gas and infrastructure sector.
Mr. Parmeshwar K. Parmeshwar, earlier Sir was advocate on record. He hails from Cochin, Kerala. He has graduated from NASA University in Hyderabad and has extensive experience in constitutional and administrative law. He has been appointed amicus curiae in several cases, having national ramification, including All India Judges case for implementation of the second Judicial Pay Commission. His keen understanding of legal principles and his dedication to practice and formation of the legal fraternity.
Mr. Prasenjit Keswani. Mr. Keswani graduated from Campus Law Center, University of Delhi in the year 1999. With over 18 years of experience in litigation, he has a strong background in corporate law and has successfully navigated complex commercial disputes. He worked under the guidance of Hon'ble Mr. Justice U.U. Lalit in the early years of his career.
A renowned advocate practicing at Supreme Court of India with over 2 decades of experience in the legal field. He has established himself as a prominent figure in the Indian legal system. Mr. Jain embarked on his journey as an advocate in 2003, and since then he has dedicated himself to providing expert legal services to his clients and also and is also a chartered accountant.
Dr. Purvesh Jitendra Malkan. Dr. Malkan has been an advocate of record in the Supreme Court of India. He completed his graduation from Symbiosis Law College, Pune in the year 2003. He started his practice from the city of Ahmedabad, which transcended state borders to record all the way to the hustling Delhi to make his way in the Supreme Court. We welcome you, sir.
Mr. R. Nedikan was an advocate on record, a lawyer hailing from Dharmpuri district in Tamil Nadu. He completed his LLB from Faculty of Law, Delhi University, and represented the state of Tamil Nadu as a standing counsel before the Honorable Supreme Court.
Mr. Rahul Kaushik. Mr. Rahul Kaushik has been an advocate on record in the Supreme Court of India. Over years of practice, he has built a name for himself in corporate and commercial litigation. He has also served as secretary of SCBA. His legal acumen and dedication have earned him a well-deserved designation as a senior advocate. We welcome you, sir.
Mr. Rishi Malhotra has been an advocate on record in Supreme Court of India. Sir has decades-long of experience in litigation and is well known for his expertise in criminal law. His dedication to the cause of justice and legal profession has earned him his wealth of certification.
Mr. Romi Chapo. Mr. Romi Chapo has been an advocate on record in the Supreme Court of India. He started his practice from Kerala High Court in 1990. Later he shifted his practice to Supreme Court in 1995. With years of practice at the bar, Sir has been a prominent figure in constitutional and service law.
Ms. Rishi has been an advocate on record for the past 17 years. She hails from Delhi and completed her graduation from Delhi University. She is a third-generation lawyer having expertise in criminal, environment and family law. She is currently Additional Advocate General for State of Haryana and represents the Union of India before the Supreme Court.
Mr. Rudreshwar Singh. Mr. Rudreshwar Singh is from Ara, Bihar and has decades of experience at the Supreme Court. Sir has been instrumental and has argued a plethora of cases involving constitution, corporate law and corporation and corruption matters besides national and international arbitration. His humble behavior and dedication to the cause of justice has earned him laurels of the bar.
Shashadri Shekhar Ray has been practiced for 3 decades, a law graduate from Campus Law Center, Delhi. Sir has a renowned for his expertise in
Advocate on record, Mr. Farasat, with his extensive experience in constitutional law and human rights, has been a strong advocate for social justice. Mr. Sant Kumar V. Mahale. Mr. Mahale has been in practice for years at the Supreme Court. He has completed his graduation from JSS Law College, Mysore. Sir has specialized in civil and commercial law. His deep understanding of legal principles and his commitment to the legal practice have earned him a designation as a senior advocate.
Sharanveer Singh Thakur comes from Jammu and Kashmir. Thakur is a law graduate from Bangalore University, holds an LLM from University of Warwick, UK, and is currently serving as Additional Advocate General for State of Uttar Pradesh in Supreme Court.
Ms. Shashi Kiran. Ms. Shashi Kiran has been an advocate on record at the Supreme Court. She has served as a prominent panel advocate at corporations such as Delhi Metro, MTNL, HAL, MCT, Union of India, Ministry of Railways. She has built a strong practice in family and matrimonial law. Her empathetic approach and legal expertise have earned her a well-deserved designation.
Mr. Shekhar Gowda, Shekhar G. Devasa. Shekhar Gowda has been an advocate on record. Sir has a specialization in civil and criminal law. His dedication to the cause of justice and his extensive legal experience has earned him the respect and recognition in the legal community. Sir, please be welcome.
Mr. Uday Bhaskar Dubey. Mr. Dubey has been an advocate on record at the Supreme Court. Over the years, he has emerged as a prominent practitioner in civil and commercial law. His legal acumen and dedication have earned him a well-deserved designation as a senior advocate.
Mr. Vishnu Mehra. Mr. Vishnu Mehra has decades-long experience in litigation. Sir has earned a name for himself in corporate and commercial law. His strategic insights and ability to navigate complex legal challenges have made him a prominent voice at the bar.
Mr. Yashra Singh Deoria. Mr. Yashra Singh Deoria has been an advocate on record. Sir is known for his expertise in tax and corporate law. His dedication to the practice and his legal expertise have earned him recognition as a leading advocate.
Moving towards the concluding part of today's program, I will request Ms. Rashmi Singhania to deliver the vote of thanks.
On behalf of Adivakta Parishad Supreme Court Unit, I would like to extend our heartfelt gratitude to our esteemed Chief Guest, former Justice U.U. Lalit, for enlightening and envisioning us on the new era of criminal laws. Your insightful had not only provided clarity and guidance, but also significantly impacted the way we should practice them. Your contribution to the legal arena and continue to will inspire generations to come. I would also extend my heartfelt appreciation to our esteemed guest of honor, Senior Advocate Sri Mahesh Jethmalani ji. His insights and expertise and experiences have enriched our understanding to the complex issues surrounding new criminal laws. His thoughtful demonstration has incited thought-provoking discussions and provided valuable guidance for future endeavors. His presence has made our study circle a vibrant and intellectually stimulating experience. I would also like to extend my heartfelt gratitude to dignitaries and the senior advocates and the newly designated senior advocates of yours. Your presence has lent a significant weight to our event. Last but not the least, I would like to acknowledge the tireless efforts of our team, the organizing committee, their dedication, hard work, meticulous planning, and which has ensured the success of today's study circle. Thank you. Last, I would request all of you to kindly join me for the national anthem.